Imo State Governor Hope Uzodinma moves to stop Supreme Court from hearing appeal on October 31st, 2023. Good evening, good afternoon, good morning, depending where you're watching this video from and the time you're gonna see this video. I remain my humble self, the Ike Man. If you're coming across my page and my channel for the first time, I would like you to share my videos, like, comment, and also follow me and subscribe to my YouTube channel if you have not done so. And remember to send stars to support my updates as updates master where I be. Until I saw this particular news and I decided to go a little bit deep into the news. I never knew that the case of Imo State is still in court till today. I was surprised and confused at the same time when I saw this news that some people still have a case in court against Hope Uzodinma. All of us know what really happened in the case of Uzodinma. And the people that took this man back to Supreme Court now are not seeking for the court to declare them winner. Because according to them, they say that under APC, that Uche Nwosu was disqualified for double nomination. Under the same APC, the Supreme Court declared Hope Uzodinma as the winner of the election under technicality. So my question now is, if the Supreme Court will use this opportunity to correct their mistake that time, are they going to declare Ihedioha back as governor of Imo State? And if such a thing will happen, will Ihedioha continue from where he stopped, or is going to continue from where Uzodinma stopped? This is really a confusing issue in Imo State right now. This is really a confusing issue in Imo State. But let's dig deep and see the nitty-gritty of this news and see where these people are going to. Imo State Governor Senator Hope Uzodinma is said to have intensified moves to stop the Supreme Court from hearing an appeal on the 2019 Imo governorship election, which the Apex Court has already fixed for October 31st, 2023, 11 days to the November 11 governorship poll. Uzodinma is seeking re-election on the platform of All Progressive Congress. The governor's apprehension is that in considering the ruling on the appeal, which borders on the disqualification of APC to participate in the 2019 governorship election, the Apex Court could reach a decision that might upend his governorship as it were and do the same to his re-election bid. The notice, which has got Uzodinma running helter-skelter, is between Ugumba Uche Nwosu, appellant, and Action People's Party, and 3 others, signed by the Registrar of the Supreme Court, Osman, and dated October 16th, 2023. It reads, listen very well. Take notice that the above appeal motion will be listed for hearing before the Supreme Court of Nigeria sitting at Abuja on Tuesday, 31st of October 2023. It continued and further take notice that in accordance with Order 2, Rule 1 of the Supreme Court's Rules 1985 as amended, this notice is deemed significantly served on you if it is left at your address of service or sent by registered post, and since the date of service by post is material, Section 25 of the Interpretation Act 1954 shall apply. There are credible feelers that Governor Uzodinma has been running helter-skelter trying to pull the necessary strings to stay the hearing of the appeal motion by the Supreme Court. The People Democratic Party (PDP) had also filed its appeal motion on July 9, 2020, seeking the Apex Court to enforce its judgment that disqualified APC from the 2019 governorship election. Sundry media reports on Friday morning said that the Supreme Court was sent to hear the motion by the Action People's Party (APP) and PDP seeking enforcement of e-judgment that disqualify All Progressive Congress (APC) from 2019 Imo Global poll. Both the PDP and APP had applied to the Supreme Court to give effect to e-judgment, which was delivered on December 20th, 2019. The party are worried by Governor Uzodinma's move to stall the hearing of the appeal motion by the Supreme Court on October 31st, 2023. Meantime, here is the meat of the matter. Listen very well, guys. The judgment had disqualified Uche Nwosu from Imo governorship election on the ground of double nomination. The Apex Court held in judgment delivered on December 20, 2019, found that Nwosu was nominated by both Action Alliance (AA) and the All Progressive Congress (APC) and consequently nullified his nomination. A political party is not capable of sponsoring two candidates for the same office in the same election, the Supreme Court had reasoned. This had informed the decision of the PDP and APC to file different applications at the Supreme Court seeking that the PDP candidates PDP candidate Honorable Emeka Ihedon be declared the winner of the election since APC was preluded from sponsoring two candidates in the Imo State governorship election. In an affidavit filed in support of the application, which was disposed to by a legal practitioner working in the legal department of PDP, he averred thus: the third respondent applicant, PDP, is neither in any way seeking a review of the valid, substantive, and well-considered judgment of this court delivered in the appeal, nor seeking a review of the judgment of this court delivered on 14th January 2022 in SC/462/2019, but rather it is humbly seeking that this court give effect to its judgment delivered on 20th December 2019. That this court has the constitutional inheritance power and jurisdiction to grant the relief sought and give effect to its judgment. That it is in the interest of the justice for this court to exercise its wide power in favor of granting its application as prayed. In the application, PDP is seeking the court to declare that the governor of Imo State, Gov Uzodinma, was not the candidate of the APC based on court judgment that nullified Uche Nwosu, who was nominated by both the APC and the Action Alliance. PDP, which sees itself as advantageous position to award the governorship position if the court uphold its argument, asked the court for an order enforcing or otherwise directing the enforcement and or giving effect to the judgment of the court in the case delivered on the 20th December 2019, wherein the court held that Nwosu was nominated by both APC and AA and consequently declared his nomination nullified. Specifically, the PDP asked the Supreme Court to hold that both the Action Alliance (AA) and the All Progressive Congress (APC) did not sponsor and or field any candidates for the governorship election held in Imo State on 9th March 2019. In view of the double nomination of applicants /responded by the two political parties, the PDP and APP, and his subsequent disqualification and as their gubernatorial candidate had found by his honorable court in the judgment delivered on 20th December 2019. The party asked the court for an order Sequel to the above that Senator Hope Uzodinma was not a candidate by himself or of any party at the Imo State governorship election held on 9th March 2019. PDP also asked the court for an order directing the Independent National Electoral Commission to withdraw the certificate of return issued to Senator Hope Uzodinma. It asked the court for an order further directing the fourth respondent to issue a certificate of return to the gubernatorial candidate of the third respondent applicant, Right Honorable m0ves in Imo State governorship election held on 9th March 2019 as the duly elected governor of Imo State, having scored the second highest number of votes in the said election, sequel to the judgment of this court in appeal number SC 1/1462/2019. Hope Uzodinma and m0ves versus Right Honorable m0ves, an order delivered on 14th January 2022. The party further sought an order sequel to the above, directing that the said gubernatorial candidate of the third respondent applicant in Imo State governorship election held on the 9th March 2019, Right Honorable m0ves be immediately sworn in as the governor of Imo State. PDP stated the ground for the applicant thus. The court found that the applicant respondent was nominated by both APC and AA as their gubernatorial candidate for the Imo State governorship election and conclusively held that he was disqualified by the provision of S37 of the Electoral Act as amended for double nomination. B. That after the said election, the governorship candidate of the third respondent applicant, Right Honorable m0ves, was returned by fourth respondent as the winner of election and consequently sworn into office. C. That subsequently the return of the governorship candidate of the third respondent was challenged up to their court by one Senator Hope Uzodinma, who claimed to be gubernatorial candidate of APC. 3. That the Supreme Court in e-judgment delivered on 4th January 2020 held that it was the said Senator Hope Uzodinma and not Right Honorable m0ves that scored the highest number of votes in the election and ought to be returned as the duly elected governor of Imo State. 4th, that all the clear terms of the judgment in this appeal, neither AA nor APC feeded any candidate for the Imo State governorship election held on 9th March 2019, and as such, the said Governor Hope Uzodinma could not have been returned as the winner of the Imo State governorship election as a candidate of the APC. 5th, that APC could not have substituted the applicant with a view to further nominating the said Senator Hope Uzodinma as their candidate because that right was not available to the party under the Electoral Act. 6. That Senator Uzodinma could not have been a candidate in the election as an independent candidate. As such, right is not available to him. 6th, that the third respondent, PDP, as the main beneficiary of the judgment ought to enjoy the fruits of the said judgment. 7th, that Right Honorable m0ves, who was the candidate nominated by the third respondent applicant and who scored the second highest number of votes after Senator Hope Uzodinma from the judgment of this court, ought therefore to be issued a certificate of return by the fourth respondent and sworn in accordingly. Lastly, that it will advance the cause of justice to grant his application, particularly as none of the parties will be prejudiced by its grants. To be frank with you, this particular Imo State case is confusing me because, like I said before, until now, I don't know that these people are still in court. But my question now is, if the Supreme Court decided to correct their mistake, because all of us know what happened, under technicality, they declare somebody that was not even a candidate. Because according to what these people are saying here now, Ihedioha is not even a candidate, was not even a candidate of APC. The main candidate of APC was Uche Nwosu, who was disqualified because of double nomination. Because during that time, I know that the former governor of Imo State, Oroja Okorocha, wanted to play again with his in-law, and something happened, and the man was disqualified. Then Supreme Court now declared Hope Uzodinma as the winner of the election, somebody that did not even contest. So I don't know how this thing will play out. Even if the Supreme Court will now go back to correct what happened that time, are they going to declare Hope Uzodinma? Are they going to declare making her back as the governor of Imo State? If such a thing happen, what will really happen? Is he going to start from where he stopped or where Hope Uzodinma stopped? We are really confused. Well, we are waiting for them to know the outcome of the hearing on the 31st of October. And so I watch this video to this and try to share the video. Like, comment, and follow my page if you are not following me. We move regardless.